Hello, this is Matt on the Moon Family Said Dan channel. Mark Cuban of Shark Tank fame agrees with attorney John Deaton on an issue that's crucial in the SEC v. Ripple case. In fact, in a recent thread from attorney John Deaton, Mark Cuban responded, interjected with his perspective, and ultimately ended up retweeting attorney John Deaton. And at the time that I'm recording this video, that retweet of what attorney John Deaton had to say has been viewed 2.7 million times, which is astonishing. Now, of course, Mark Cuban, he does, as you can see on your screen here, have 8.8 million followers all up on the Twitter. So I guess in that sense, maybe it shouldn't be that surprising, but the number's staggering either way, even if we should expect it because he has a huge following here. And so this is helping to spread the word. How's that for some cooperation, huh? So definitely Mark Cuban knows what's going on in the SEC v. Ripple case. So I'm going to share with you the specifics and what led to this, attorney John Deaton's message, all that jazz. But before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And if you don't like it, well, you can just get out. So here's what attorney John Deaton had to say, which ultimately Mark Cuban responded to. So I'm going to go through this first, and then I'm going to share with you Mark Cuban's comments. So this is from attorney Deaton. He wrote, "Notice, as everyone is aware, Gary Gensler and the SEC sued Coinbase and Binance US. Just like the Ripple case, the SEC claims that it filed the lawsuits on behalf of digital asset investors, users, and holders. The SEC claims it is protecting us." Folks, tell me, do you feel protected by Kim Jong-Gensler, who is the supreme leader and dictator over at the SEC? Do you feel protected? The actions that he's taking, is it doing anything to improve your net worth or harm your net worth? Because I'm telling you, if the mission that's stated from the SEC is true, which is that of investor protection and helping in regards to capital formation, why aren't we seeing those things happen? Anyway, attorney Deaton continues. Coinbase applied for the acceleration regarding its IPO. Before the SEC approved the acceleration, it had to make a specific determination that the listing was in the public's interest. And by the way, so I have seen some people push back, and I appreciate the conversation, so don't get me wrong, it's fine that people share dissenting views, especially if they're attorneys. I find it fascinating. But I have seen attorneys, as I've highlighted, that actually make the argument, and I'll be talking about this more in future videos, I'm sure. There's a lot to unpack there, actually. It's just not for the purpose of this video, but I'll just mention it anyway. There are attorneys out there that are arguing that the purpose of the filing, in case of Coinbase's IPO, was not to determine the legality of the cryptocurrencies being traded, this or that. So some are pushing for the SEC to have a free pass on that. Now, I think that's bogus. I do not buy that argument. And thoughtful minds can respectfully disagree, and okay, that's fine if they're saying what they really believe here. But again, it's unquestionably the case that the SEC had to make the determination that their approval was in the public's interest. Now, how could that be the case if they haven't gone through due diligence to understand if pretty much everything that Coinbase is selling is a security, which would be illegal, right? How is that? It doesn't make logical sense, and I don't think you need to be a lawyer to understand that part. Anyway, attorney Deaton then says, 2 years later, the SEC claims it's in the public's interest to permanently shut down Coinbase. I filed an amicus brief on behalf of 75,000 plus XRP holders in the Ripple case. The amicus brief is attached here for your review. Please notice that I filed the brief in opposition to the SEC's motion for summary judgment, not in support of Ripple. As amicus, we didn't defend Ripple. We took no position whether Ripple violated securities laws when it sold XRP. Our position was XRP, like Bitcoin and ETH, is digital code. The token itself is not a security, and even if Ripple violated the law, secondary market sales do not. And also, I'll note here, I think that attorney Deaton's approach on that was absolutely the best approach. Because what he's doing, obviously, again, very clearly, it's to protect XRP holders, period, right? So if you're doing that, and he is, then you want to stay on point with your message. So if he had gone off and started supporting Ripple this or that, Look, Ripple's already got their defense. So I think that the point that Attorney Deaton is making here is a rather salient one. And as a result, I mean, I think it's unquestionably, like, we'll see, the history books are yet to be written here, but I think that it's when this decades from now, when this case is viewed as a case study, for legal minds in college, so on and so forth, I think that it's going to be widely accepted that Attorney Deaton's role in representing almost 76,000 XRP holders was absolutely pivotal in receiving a positive outcome. I am optimistic we're going to have that positive outcome. But anyway, Attorney Deaton continues. The Coinbase and Binance lawsuits share some common themes and characteristics, but at the same time are quite different. I am not conflating the two, and I understand the differences. Just as I approached the Ripple case, I have no intention in defending these companies. As I said to the judge in the Ripple case, I expect Ripple to look out for Ripple and not individual XRP holders. The same applies to Coinbase and Binance. But the SEC is not acting in the best interests of retail crypto holders, and that is for sure. The SEC has an agenda. As I did in the Ripple case, I have a Google form to establish a putative class of customers and crypto account holders who use these platforms. If there's interest, we can ask to participate and possibly be granted amicus status in an effort to make sure our voices are heard. Your name and email will not be shared or provided to anyone unless ordered by a court. Again, this isn't about whether Binance or Coinbase did anything wrong. They have lawyers to defend them. Some of us just don't want the SEC gaslighting the court that is protecting us. And then he has a link to there, and he notes that if you go to his Twitter account, it'll be pinned to the top. So anybody can participate if they so choose. Now, it's so fascinating. I mean, John Deaton may be like the most at this point, honestly, probably, I think it's fair to argue, the most well-known attorney having anything to do with crypto. That's probably true, to be honest with you. And so he's participated, obviously, in the SEC v. Ripple case, in the library case. Now he's seeking to get involved here with Coinbase and Binance. And he's doing what the SEC won't and seeking to protect investors. And it's resulted in him being on Fox Business Network and all sorts of major mainstream publications, not just crypto media. And it's absolutely fantastic. I don't know what the landscape would look like right now had he not chose to jump in, because he's the one that did it. And I appreciate all the other attorneys that have contributed in the ways that they have, of course. But when it comes to actually taking action in a legal sense, it's Attorney Deaton. And he jumped in right from the very beginning. And there's a reason that all of us here in the community are so damn appreciative. And it really is. Like, he's doing the work that frankly, he's protecting us. Like, that's the work the SEC should be doing. The SEC is not protecting us. He's protecting us from the SEC, which is harming our net worths. So it'll be interesting to see how this all plays out. But Mark Cuban, he responded to Attorney Deaton at this point in the thread where John Deaton was talking about as amicus, he wasn't defending Ripple. That tweet, it's on your screen right now if you want to reread it. And Mark Cuban responded to Attorney Deaton and said the following. The test for a secondary sale of a token as a security should be very simple. Will the token survive if the minting/mining organization fails to exist? That, by definition, ends the Howey test application. Spot on. So Mark Cuban absolutely gets it. And Attorney Deaton clearly agrees, of course, and he expands upon this. He says, exactly, Mark. Some call it the Bahamas test. If the organization/entity that offered, minted/mined the token were to pick up and move to the Bahamas, never to be heard from again, or do anything further with the project, would the token survive? If it would, not a security. And look, I remember in the earliest of days, for me, being in crypto, I've been in crypto since the end of 2017. And I remember the earliest of days, it may have actually been in 2017, if not, then certainly 2018. But I remember seeing this discussed, and I'm pretty sure it was Brad Garlinghouse that was saying even back then, if Ripple just ceased to exist, XRP and the XRP ledger would continue to exist. Of course it would. They're two completely separate entities. One's a company, and one is a cryptocurrency on decentralized distributed ledger technology. So, of course it would exist. But again, of course, if that's the case, what the hell are we even talking about here? that should end the need for any sort of Howey analysis. Of course it should, because there's not a freaking common enterprise as it pertains to the token itself, right? There can't be. Now, if you want to talk about individual sales, I still say, of course that's fine. Go ahead and do that. When you're talking about the token itself, get the hell out of here. So that last comment, that tweet from Attorney John Deaton, that's the one that was retweeted by Mark Cuban with his 8.8 million followers. And here you can see on the screen, it has been viewed at this point 2.7 million times. And that was since yesterday. So 2.7 million times. And then Mark Cuban expanded upon this line of thinking here and just pointing out the hypocrisy and nonsense of the SEC and the degree to which they're picking and choosing what sectors they want to go after vindictively. And Mark Cuban wrote the following. Here is the SEC. Oh, I'll just make this full screen. I'm not going to read the image that he shared because I think it's not necessary to kind of make the point here. But if you wanted to pause here and read that, it's on the screen. I just want to give you the opportunity if you so choose. But Mark Cuban is referencing this little screen grab that is on your screen right now. And Mark Cuban wrote the following. Here is the SEC calling the stock loan industry opaque and requiring transparency. Note, they are not calling stock loans a security, as they are trying to do with the loaning of crypto assets. Nor are they suing the stock loan departments of brokers/banks. They are going through a comments process. They should do the same thing with crypto as an effort to determine which aspects of crypto are securities and which are not, and the best way to regulate the industry and protect investors. I think their difference in approach is emblematic of their intent for one industry versus another. Ding, ding, ding. Picking and choosing which sectors you want to go after because the SEC has motive. And we can't get in their hearts and minds. But part of the reason that we can't is because they don't have hearts. They're not actually human, as it turns out. They're just spawns of Satan, actually. Little asshat pricks. But in terms of their minds, they do have minds. And I'm sure there's a bunch of disgusting stuff up in there. So we can't know for sure why they're doing it. We can observe they are doing this, and it's certainly not right. And Mark Cuban, he obviously despises the SEC. For those of you that aren't aware, he had his own goings on with the SEC. They accused him of some stuff and back in the day, and it's estimated that he could have settled with the SEC probably for about $2 million, but he's like, no. Then my name is forever going to be tarnished. No, I'm going to fight back. And it's rumored that he spent somewhere in the neighborhood of $16 million fighting the SEC, and he won. So, again, could have spent $2 million, ended up spending $16 million, but he won and his name's intact. So probably from his perspective, since he's ridiculously wealthy, very well worth it. But it just shows you, like, the SEC is wrong all the damn time. And it's very clear when it comes to all this stuff pertaining to crypto, their general thesis is disgusting and wrong, and it harms people. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.